All right, thank you everyone for joining us today. We have a special presentation coming from attorneys Daniel and Peggy from Pregenzer, Baysinger, Wideman, and Sale, and they're going to go ahead and present legal roadmap planning ahead for dementia caregivers. Thank you for joining us, Daniel and Peggy.
Absolutely.
Thank you.
All
Okay.
right.
Are we ready then? You want me to start?
We're all ready to start whenever you guys are.
Okay. Well, thank you, Denise, and good morning, everybody. I really wish we could be doing this in person, but I guess it is what it is right now. I still, if possible, I'd like to keep this as interactive as we possibly can. I know that Denise mentioned that we would take questions at the end, which we certainly will. We'll set aside time for that. But perhaps if you have burning questions as we're going through our presentations, I think go ahead and use that chat feature. And Denise, I presume you'll be monitoring those as they come in. And please don't hesitate to interrupt me so that we can address whatever questions that you might have at that time. And again, we can also do it at the end as well.
Sure. I'm going to actually ask my colleague Pam if you're on this call, because if I'm sharing the screen, I have to unshare my screen. So Pam, if you're on this call, would you mind building the chat questions for me?
That would work perfectly.
Oh, great. Thank you, Pam.
Okay, thank you both. What we're going to try to do is focus this as much as we possibly can towards the information that you all need and want and questions that you might have. So that being said, this outline that we've got, the PowerPoint slides that you'll see going through this, there will be, a lot of slides with a lot of information. Some of it I'm going to skip over just because I don't think it's as pertinent to the discussion that we're going to have today as other points on these slides. So I'm going to try to focus this as much as possible to kind of the fundamentals of estate planning and what we need to do to get dementia caregivers the authority that they need to make financial and personal care decisions for their loved ones that they're taking care of. So with that, if you would, please, Denise, next slide or the first slide. Question on this slide is, what is estate planning? I think, most people, when they hear estate planning, they just automatically think that's just a last will and testament and what's going to happen to my assets after I'm dead. That's certainly a part of estate planning, but a comprehensive estate plan could also address planning aspects for the probability or the possibility of us becoming incapacitated during our lifetime. And that planning would involve the necessary powers of attorney to have in place so that somebody, typically family members, would have the authority to make personal care, health care, medical decisions, and also to manage the assets of that individual in the event of incapacity. And that point or that part of estate planning is going to be the focus of the presentation today. Next slide, please, Denise. Thank you. Typical estate planning documents. I'm just going to go through this list very quickly. Most of these you probably know. First, last will and testament. Next, revocable living trust. The third and fourth are financial and healthcare powers of attorney, and the last is a special needs trust. For purposes of this discussion today, I think we're going to primarily focus on the revocable living trust. That is a good lifetime planning tool, which we'll get into in a few moments. We'll talk about the financial durable power of attorney, and we'll also talk about the advanced healthcare directive. In my opinion, I've been an estate planning attorney for coming up on 30 years. In my opinion, I think probably two of the most important estate planning documents for any client is the financial durable power of attorney and the advanced healthcare directive. And again, we'll talk about that a little bit later. Next slide, please, Denise. Thank you. What's probate? There's, most people, when they hear probate, they automatically think it's a terrible thing. There's a lot of bad information out there about probate. In New Mexico, we have adopted what's referred to as the Uniform Probate Code. And the intent and purpose of the Uniform Probate Code is to make the administration of a probate estate manageable and not overly expensive and efficient. And for the most part, it does work. Now, probate does deal with the transfer of assets when somebody dies. The intent or the purpose of probate is to transfer assets from a decedent to his or her heirs or beneficiaries that they've designated under their will. Probate also deals with guardian and conservatorships, and Peggy is going to talk about that later. So really there's two big components of probate. One is transferring assets at death, and the other is setting up guardian and conservatorships for individuals who are incapacitated. Next slide, please, Denise. How do I avoid probate? This is probably one of the most common questions that I get as an estate planning attorney, and we're just going to kind of go through these quickly because, again, this is not really the focus of what we're talking about today, but I just wanted to give kind of the fundamentals or a foundation of estate planning so that as we move through this. Ways to avoid probate: joint tenancy. If I own an asset as joint tenants with somebody, when I die, ownership automatically passes to the other joint owner. The next is pay on death, POD, or transfer on death, TOD. Those are designations that you can put on typically bank accounts, on investment accounts, where the account is titled in your name, but it pays on death or transfers on death to the beneficiary or beneficiaries that you've designated. It passes without probate. And similar to the POD and TOD, you've got beneficiary designations on life insurance policies, annuities, and retirement accounts. And then the last one, probate avoidance technique, is a trust. I mentioned earlier that revocable living trust was going to be one of the tools that we were going to talk about today. It's a lifetime estate planning tool that you create. The assets that you put into that trust, when you die, those assets will not be subject to probate. Next slide, please. We're not going to spend too much time on this. Will my estate be subject to estate tax? Currently, there's an estate tax exemption of about $11.5 million. So if your estate is below $11.5 million currently, then no, there will not be any estate tax payable when you die. Now, the estate tax exemption, that is a moving target. It is constantly changing. When I started practicing law, the exemption was $600,000. Today it's 11.5. And who knows what's going to happen. There is a good chance that it's going to be reduced, but we don't know that. Do I need a trust or will? That's a very, very common question that I get, and a typical lawyer answer is it really depends on your particular situation. And I don't want to get into too many of those details today because I don't want to divert from the topic at hand. But so in any event, that's all on that one. If there are questions on that, by all means, I'd be happy to answer it. Next slide, please. Common estate planning mistakes. There's a few of these that I do want to hit on for purposes of the discussion today. The first one, doing nothing and hoping for the best. I don't know how often I have clients come in where their mother and or father have done no estate planning. They've developed dementia, or they've had a stroke, and they're now unable to manage their affairs, their financial affairs, or make healthcare decisions for themselves. A lot of people that I run into, and I think Peggy probably experiences the same thing, is that People think, oh, I'll never become incapacitated. That always happens to other people. It's not going to happen to me. And there's also the individuals who think, well, I'm not going to die till I'm 100. And, we just don't want to face the possibility of our incapacity or our death at an age younger than what we would hope for or anticipate. And I think we're all guilty of this to some degree. I mean, I certainly am. But doing nothing and hoping for the best is a huge mistake. Another one that I want to address on there is the fourth one, assuming that all of your beneficiaries will get along. And when I use beneficiaries there, I'm referring to children, family members, and friends, loved ones. In my experience, and I'm probably a little bit jaded because as an attorney, I get to see the things that don't go the way that people would like them to go. But typically, people don't always get along. I've got many, many situations where mom or dad has become incapacitated and the kids are now fighting amongst themselves about who is going to be the one to make healthcare decisions and to manage assets. So doing the pre-planning can avoid and hopefully prevent a lot of those fights that do occur. And some of those fights, unfortunately, get so nasty. I've seen a lot of families just kind of fall apart. And once mom and dad are deceased, then that's it. They never talk to each other again. So again, pre-planning can address and hopefully prevent a lot of that stuff. The next bullet point, the last one I want to address on this slide, is attempting to do it yourself. One thing that I see on a fairly regular basis is there's multiple children. Let's say dad is deceased, mom is still alive, and one of the children is taking care of mom primarily. Mom is moved in with that particular child, and mom transfers all of her assets into joint tenancy, or perhaps even transfers ownership outright to this one child, so that he or she can manage everything for her. And mom, the presumption is that, oh, this child is going to share it with everybody when I'm gone. Well, that's kind of a do-it-yourself estate plan, and in many, many instances, it just doesn't work. So I would encourage everybody, just because I'm an estate planning attorney, I'm not trying to sell our services by any means, but at least visiting with an estate planning attorney to find out what your options are and how to do it. Next slide, please. This one is before we worry about a guardianship. The title of this should actually be before we worry about a guardianship and conservatorship. There's alternatives to that, and Peggy is going to get into what guardianship is and what conservatorship is in New Mexico. Those are judicial proceedings. So what we can do to hopefully avoid having to go to court, I mentioned earlier, two of the most important estate planning documents that anybody can have are powers of attorney for healthcare and for finance. With those documents, you are appointing an agent or agents, typically your spouse, your children, your close friends, your life partner, whatever it may be, but you are appointing them to make the healthcare decisions if you become incapacitated and are unable to communicate what you want with the doctors. And you appoint an agent to make financial decisions for you, to manage your assets if you're unable to do it. In parentheses there after finance is durable. All of you have heard the term durable power of attorney. All durable means is that it survives your incapacity. So in other words, if I have a durable power of attorney and I appoint Peggy, and next week I suffer a stroke and I'm unable to manage anything for myself, that power of attorney is still valid and enforceable, even though I'm now incapacitated. So primarily what you're going to be dealing with in estate planning is going to be durable powers of attorney so that they remain active and valid in the event that you should become incapacitated. The next bullet there is healthcare surrogate. And I'll get into that a little bit later. So if we could just jump to the next slide, please.
Okay, I'm going to just welcome if there's any questions at this point. We can read those.
Excuse me. Hello?
Are there any questions at this point? Okay, so then we'll move along.
Okay. Healthcare power of attorney. I'm not going to go through all of the points on here, but as I mentioned a moment ago, a healthcare power of attorney and advance directive, as its name would imply, it's two parts. The first part is where you appoint an agent to make healthcare decisions for you if you are not able to do it yourself. And then part two is the advance directive. That's where you set forth your end-of-life decisions, whether you do or do not want extraordinary means of life support. To sign a power of attorney, whether it be financial or healthcare, the individual must be able to understand what he or she is signing. And in my experience, I've had a number of clients who they do much better, for instance, early in the morning than they do late in the afternoon. It just, a lot of it is, it just depends on the situations. I've had some clients who function much better in their own home than they do in my office. So in some of those situations, I will visit with the client at their home, or we'll make arrangements to meet with them at a time of day that is best for them. So the point that I'm trying to make is to be to have the capacity to sign a power of attorney. It's not a black and white answer. It may be in the morning, yes, this person has capacity, but late in the evening or afternoon, no, I would say that he or she doesn't. So it just kind of depends on the individual and the situation where they are. The healthcare power of attorney, basically it gives the agent to make any and all medical decisions for that individual that granted the power. Next slide, please, or it looks like maybe we've lost the slides. There we go. Next one, please.
Sure. Hold on one second. Okay. Sorry about that.
That's all right. Financial durable power of attorney, again, same issues. You have to have the capacity, the mental capacity to sign it. Do you understand it? What it does is it gives your agent the authority to do basically any and everything with your assets that you've given them the authority to do. You can limit it as much as you want, or you can keep it very, very broad, giving that individual, your agent, to make any and all decisions. So it's really up to the client how restrictive they want to be with that power. As I mentioned earlier, the powers of attorney can be invaluable in the event that somebody becomes incapacitated. With the power of attorney, those individuals that you've designated as your agents are going to be able to step in and take care of things for you. Go ahead and skip over the next slide and just get to the one that's titled Healthcare Surrogate. Thank you.
Excuse me, we have 2 questions in the chat currently.
Okay, do you want to present those now, or I'm happy to take them?
Okay, Michelle is asking, is a durable POA the same as a POA?
Yes and no. A durable power of attorney, as I mentioned earlier, is the term durable means it remains valid in the event that the individual becomes incapacitated. So you do want to be careful. There would be very limited reasons from an estate planning perspective why you would not use a durable power of attorney. If it's not durable, For instance, I could sign a power of attorney today that I give Peggy the authority to manage my assets on my behalf. But if it's not durable and I have a stroke tomorrow, Peggy's authority ceases as soon as I become incapacitated. So the power of attorney portion is the same. You're giving somebody decision-making authority for you, but the distinction there is being durable versus non-durable. So I hope I've answered that question.
There is a second question, Daniel.
Okay.
And it is from Dee Dee. Dee Dee wants to know, how does the HCPOA advance directive work in concert with the New Mexico MOST form?
You know, that's actually a very good question. And Peggy, I would appreciate your input on this if you don't mind, because I think you've dealt with this probably more than I have.
Sure, I'd be happy to. So typically they work together. The MOST form is a form that a lot of the hospitals provide or use as far as identifying what somebody wants going forward once the doctors, healthcare providers determine that an individual isn't likely to survive without extreme medical intervention. The MOST form typically is a little bit more hospital specific versus if you're in hospice care or something of that nature. And it does go into a little bit more detail typically about other things that you may want at the time of your death, such as clergy present or not present or anything specific of that nature. But really they should work together, and it would be important that if you have a MOST form and an advance directive that they're consistent, and that one doesn't say do not resuscitate, no heroic measures, and the other one says heroic measures, because then you get into conflict with which one was created first and which controls and that sort of thing. So they really should just work in concert together to address different pieces of your life that you may want to specifically designate how that end goes, but they do need to be consistent. It's important to make sure that you review that. And if you do have a MOST form, I really, really recommend that you bring that to your appointment with your attorney for estate planning so we can make sure that everything is working together and we don't have any conflicts in your documents.
Thanks, Peggy. And, you know, one thing I just want to follow up on that. Several months ago, the point that Peggy raises about the consistency is a huge issue. It was the children of an individual. She was in the hospital, unable to communicate what she wanted. She had previously signed a MOST form and a healthcare directive. And to the point that Peggy just raised, there was some inconsistency between the directions in the MOST form and in the healthcare power of attorney, which unfortunately it put the kids in a very difficult situation. They weren't fighting, everybody was happy and getting along, but it left questions in their mind as to what their mother wanted. So Peggy's point about consistency is a very big one and an important one. Denise, are there other questions in the queue?
No further questions at this time.
Okay, then I'm going to go through the next few slides fairly quickly. The healthcare surrogate, there is a statute in New Mexico that in a situation where an individual has not signed a healthcare power of attorney, then a healthcare surrogate can be designated to make decisions for that individual. So in a scenario where there's not a healthcare power of attorney and somebody is incapacitated, it doesn't necessarily mean that we have to go to court to get somebody appointed to make healthcare decisions for this individual. In a situation where the patient still has the capacity, he or she can appoint anybody that they want as their surrogate to make healthcare decisions for you. Typically, that's not the scenario. The scenario is an individual is in the hospital, he or she is incapacitated and unable to designate a surrogate. in that situation, then this is where the Uniform Healthcare Decisions Act comes in to play. There is a priority within the statute of persons who can serve as the surrogate for that individual. The first is the spouse. If the spouse is deceased or there isn't a spouse, or he or she is unable to act, then the next in the list of priority is an individual who's been in a long-term relationship with the patient. Next in the line of priority is adult children, and then next is parents, and then after that is brothers and sisters. In many situations, it works just fine. Everybody is happy and getting along, but it's the scenario where the kids, typically the kids, are fighting, and there's just, they become deadlocked on decisions. The hospital gets nervous, the doctor gets nervous as far as who really is going to be making decisions here. So this is an option if the individual doesn't have a healthcare power of attorney, but I can't stress enough how important it is to do the pre-planning, to have the healthcare power of attorney in place so that you don't have to fall back on the Healthcare Decisions Act. And basically, the next slide, please. It's just, the question is, what can a healthcare surrogate do? Basically, they can make any and all decisions for the patient pertaining to healthcare treatment and even end-of-life decisions. The one thing that a healthcare surrogate cannot do is they do not have the authority to consent to a patient's admission to a mental hospital or a mental facility. So that's the portion of this I think that I was going to cover, and then I believe Peggy is going to step in and take over the guardian and conservatorship issues.
I do have a question actually regarding the healthcare surrogate, because I've had a couple of caregivers who are sort of dealing with supporting their loved one with dementia, whether they're in a long-term care facility or whether they're hospitalized, but not being able, because of COVID, to be with their loved one to help advocate for them. And then, you know, with the progression of dementia disease, them not being able to advocate for themselves. Is this exactly when maybe a healthcare surrogate would be the person that can help the individuals or the caregiver, so they know that there's somebody there to help the person with dementia disease?
Yeah, absolutely. If the patient or the individual with Alzheimer's, if he or she does not have a healthcare power of attorney, then yes, the healthcare surrogate would be the one who could go to bat to protect the interests of that individual. But if that individual does have a healthcare power of attorney, then it would be the agent designated under that document that would be able to step in and act on his or her behalf.
Okay, and it looks like we do have a question in the chat. Where in line of succession next of kin are grandchildren?
Grandchildren would be pretty far down. Again, the first in the list is spouse, and then long-term relationship, you know, a life partner situation. Then after that would be adult children, and then parents, and then siblings. And then after that, I would have to double check the statute, but I believe that's where further descendants down the line would be able to act. So that's when grandchildren would be able to step in.
Okay, thank you, Daniel.
You bet.
Okay, are we ready to go on to guardianships then, I think? Is that the next slide?
Yes, there was some other healthcare, but I think Daniel mentioned we're skipping that. So I am on what is guardianship slide right now.
Okay, sounds good. So again, my name is Peggy Graham, and I want to visit with you guys about guardianship today and conservatorship as well. And they go together, and I'll talk about what they are and how they're used. But I do want to, again, reiterate, because we can't say this enough, Dan's point about estate planning and preparing in advance. Guardianship is a last resort, and it is a very invasive and court-driven process that subjects the individual, we call them the alleged incapacitated person, or AIP for short, subjects that individual to the jurisdiction of the court, and their decision makers are then overseen by the court, and their records are part of the public record these days. And there are absolutely reasons why that's important and necessary, and a very good thing to have. But if we can avoid that and it's not necessary, then we certainly want to do that. The courts like to look at what the least restrictive measures are as far as helping an individual with decision making, and powers of attorney are absolutely much less restrictive than a guardianship and conservatorship. So we always look at guardianship and conservatorship as a last resort. There's been a lot in the newspaper a few years ago regarding guardianships and conservatorships, making it look really, really scary and really, really ugly. And it certainly doesn't have to be, and in most circumstances, it's not. Most cases of guardianship and conservatorship are very easy, very straight to the point, and don't incur a lot of attorney fees and costs and years and years and years of litigation. So don't be afraid of guardianship and conservatorship just because of what's been in the press. And it's something that is a good tool when we need it. Okay, so a guardianship and conservatorship does involve the court, and it requires that someone be appointed by the court to make decisions on behalf of someone who's incapacitated. Guardianship and conservatorship can absolutely be avoided when proper estate planning is done, but even sometimes, and we'll talk about this in more detail, it doesn't work. Even the best estate planning doesn't work if it's not put into practice the way it should be. Next slide, please. Next slide. Okay, conservatorship. The difference between a guardianship and a conservatorship is pretty simple. A guardianship is of the person. So if you just think about what a person needs, healthcare, residential placement, social, all the things that go with the actual person themselves, that's everything that a guardian and a guardianship has jurisdiction over. Conservatorship is all the money, all the financials. So they deal with real estate and bank accounts and investments and insurance and any benefits, Social Security, all those Medicare, Medicaid, all those things, anything dealing with money, finances, and assets is a conservatorship. That's why a lot of times we'll say guardianship and conservatorship, and sometimes we only need one, and sometimes we need both. It just depends on the circumstances of the individual. Next slide. So there's been a lot of changes, and I'm not going to spend a whole lot of time on this piece of things. There's been a lot of changes to the guardianship statute, and I commented earlier about the guardianship proceedings being open to the public. It used to be that guardianship matters were what we call sequestered, and the only information that the public could get would be the name of the person and the fact that a proceeding was filed. Now, as a result of some changes that came from the legislature a couple of years ago, those records are a matter of public record, and the proceedings are open to the public. So before, the hearings were closed, and only the people who are supposed to be part of the proceeding, the lawyers and the court-appointed professionals and the alleged incapacitated person, were allowed to be there. Now they're open to the public, and the public can come in and sit in on those hearings if they choose to do that. The only things that are still protected and prevented from being disclosed to the public are professional reports that include healthcare information. So the qualified healthcare professional report, the guardian ad litem report, and the court visitor report are still closed. They're still protected, and those can't be provided or released. But other information is public, and so we do want to keep that in mind when we're talking about how that process is.
Peggy, we
Next
have
slide.
Yeah, sure. We have a
Oh,
question
sure.
real quick.
Go ahead.
How is guardianship part of the public records and abide by adheres to HIPAA?
So that's the part about the healthcare professionals, the court visitor, and the qualified healthcare professional. Their records are not public, and so the protected health information that's included in those documents then is protected from the public record. So that's how that, and so we address HIPAA in that way.
Okay.
Yeah, and and it's kind of the same thing when it comes to the hearing itself. If there's going to be specific discussion about medical diagnostic information or diagnoses and that sort of thing, the professionals in the hearing, the attorneys, can ask the court to close the proceeding for the duration of that testimony. For example, if for some reason that we need to have the qualified healthcare professional testify at a hearing, and there are members of the public that have chosen to come and sit in on the hearing, we can ask the court to close the portion of the hearing where the qualified healthcare professional is going to testify so that we protect the health information of the individual. But as soon as that person is done testifying, then the proceedings would be open to the public once again. So we do want to protect the health information, but it still does put a lot of other things about this individual's personal life into the public record, which it can be difficult for some people.
Thank you.
We're not allowed to include information in the petition like we used to. Again, we're trying to protect people's privacy since it's now open to the public. So we don't include the information that you're seeing on the slide or the healthcare professional report like we used to, but it still does have to identify the fact that we have a good faith basis to believe the individual is incapacitated. Next slide, please.
Past this one? So we're
Yes,
looking
past
at
that.
the next, okay, sorry, a process
Yeah.
of adult guardianship. Peggy,
Yep.
we did have a question as far as what is a guardian ad litem, but I think we answered that already, but if you would, I know a few lost connection and came back, so just real quick, if you can just cover what a guardian ad litem is.
So, and I think this will come up later in the slides, and so we can pass by those when we do, if we come up to it. The court is required to appoint 3 professionals. Whenever a petition is filed in a guardianship matter, guardianship and conservatorship, the court is required to appoint 3 professionals. One is a guardian ad litem, one is a court visitor, and one is a qualified healthcare professional. The qualified healthcare professional is an individual who has a basis to provide a medical reason for why an individual can't make decisions in their own best interest. That can be because they have dementia, Alzheimer's kind of process. That can be due to other medical conditions, a stroke, or a traumatic brain injury. It can be due to developmental disability, cerebral palsy, autism. There has to be an actual medical basis for why a person can't make decisions. So that's the job of the healthcare professional. The guardian ad litem is an attorney who's appointed by the court to investigate the allegations in the petition on behalf of the alleged incapacitated person. The guardian ad litem will interview all of the relevant individuals, the petitioning person, the person that's proposed to serve as guardian and conservator, definitely the alleged incapacitated person, and anybody else who might have information about what's going on with this situation. And it's their job to represent to the court what is in the best interest of the alleged incapacitated person, whether a guardianship and conservatorship is necessary, and if so, who should be appointed to serve in those roles, and also to represent to the court what the alleged incapacitated person wants. And it sometimes can be an interesting or difficult position to be in as a guardian ad litem, because sometimes you'll have an AIP who wants something that's not in their best interest. I have served as guardian ad litem in cases where I have an alleged incapacitated person who has been financially or otherwise exploited and abused by an individual, but that's the person that they know, and that's the person that's been taking care of them, and the reason they've been taking care of the AIP is so that they can ingratiate themselves and take advantage, especially financially. This happens quite a bit. And oftentimes the AIP doesn't feel like they have any other choices, and they don't know, they're afraid to not have this person making decisions for them. So they want to stay with that person who's been abusing and exploiting them, and obviously that's not going to be in their best interest. And so sometimes as a guardian ad litem, we have to recommend something different than what our client, the person wants. But typically, if the person wants something that's appropriate and in their best interest, we absolutely are going to advocate for that position. The third court-appointed professional is the court visitor, and this person has a social work background, and he or she is coming at it similarly to the guardian ad litem in that they investigate the petition and want to see if an individual really needs a guardian and conservator, and if the proposed person is appropriate to serve in that role. And they make a recommendation to the court as well. They do a little bit more from the social services side as far as making sure the person's needs are being met, and if there's anything that they need to have addressed, that's being taken care of. So those are the three individuals that are appointed by the court. And the statute, I will say, the statute for guardianships and conservatorships states that it is the estate of the protected person who pays for all of this. So sometimes you have an individual who's very resistant to this process and rightly wondering, why do I have to pay for something that I don't even want or think I need? And so planning ahead and being prepared with other mechanisms such as the healthcare power of attorney and the financial power of attorney, or a trust that addresses who becomes the successor trustee to take care of assets, is really preferable when we can make that work. Next slide, please. So the alleged incapacitated person has to be served with a petition. One of the big concerns that the legislature had several years ago was that this process not be done in secrecy. I will say it wasn't being done in secrecy before, but there are rules now that we have to follow to make sure that it's absolutely being done very transparently and clearly up front. So we do have to serve the individual, the alleged incapacitated person, with the petition, and they have the right to be told about the hearing and that they're allowed to have anybody present that they want, and that they have rights when it comes to what will happen at that hearing. Next slide, please. As I said, there's different, before the rules were amended, the hearings were automatically closed. In 2018, that changed, and so now they're open. We can still close them for, like I said, specific things as far as the HIPAA protections and that sort, but we want to be very protective to the extent that we can of the person's personal information. We don't want to use this process to embarrass people unnecessarily. We try to keep it as dignified and as confidential as we possibly can, and still comply with all of the requirements of the statute. Next slide, please.
I think I advanced too fast.
Oh, that's okay. Other way.
Okay.
There we go. So there we go. So again, they have to be personally served. The individual has the right to attend and participate in the hearing. They have to understand or be told what the consequences are if the petition is granted. And if you don't follow the rules that are set out in how this process works, then the court will not grant the guardianship and conservatorship. So we do put a lot of things in place to try and protect the alleged incapacitated person so that people aren't using the guardianship and conservatorship process for reasons that are not appropriate and not in the best interest of the loved one. Next slide, please. The individual has a right to present evidence, to subpoena witnesses, to bring documents. They can cross-examine all of the professionals that are appointed by the court, and they have full participation in the hearings. And I will tell you that All of the judges that I have appeared in front of in Albuquerque, in Rio Rancho, in Santa Fe, in Los Lunas, Las Cruces, Silver City, all of the judges, Alamogordo, I mean, shoot, all over the state, they are very, very sensitive to the individual that we're there about, and they always want to talk to that person as much as that person wants to talk to them and find out directly from the individual what they want and what their preferences are. The individual is required really to be at that hearing, and if they're not going to be, we have to show really good cause. GHP should be qualified healthcare professional. The G should be a Q. Typo on my slide as I'm seeing that. But the judges are really, really sensitive to all of this. And so if we're going to have somebody, a protected person, not attend a hearing, we have to have permission from the court ahead of time and a really good reason, such as a medical situation, that it wouldn't be in their best interest to be able to participate. And sometimes in those cases, and I have had this happen, the judges will go to the person. I've had judges go to assisted living facilities. I've had judges go to nursing homes. I've had judges go to hospitals. Just depends on what the individual situation is. So the courts are really, really sensitive to all of this. Next slide, please. So that's generally what the public can access. I'm not going to go into a whole lot of detail on that. If you have questions about it, I'd be happy to address them later. Next slide. This is the time frame that the different professionals have to file their reports. They have to be provided in advance, and all the parties are entitled to receive them so that everyone knows before we get to the hearing what the recommendations are going to be from the professionals. So we don't want to, this isn't a Perry Mason coming in the back of the courtroom with the smoking gun at the last minute situation. Everybody is on the same page and gets the same information about what recommendations there are. Next slide, please. Important to keep in mind is that the courts are now requiring bonding if there's a conservatorship in place. And when I say even family guardians, that means family guardians and conservators. Guardians, if there's only a guardianship, a guardian does not have to be bonded because they don't have the authority to deal with large amounts of money. There's one exception, which is a guardian with financial authority. If the only asset a person has is Social Security or SSI, then we can just do a guardian with financial authority. But if the individual has anything more than that, then they're going to have a conservatorship, and they're going to have a bond. A bond is basically where you kind of have an insurance policy, similar to an insurance policy, where you pay a bonding company and they have an amount, and that amount is determined by the court based upon the person's assets. So if we add up, if I'm doing a guardianship for Dan and we figure out that he's got $500,000 worth of assets, the court's going to require a $500,000 bond, which means that there's essentially an insurance policy out there so that if the conservator makes off with Dan's money, there's an insurance policy essentially that will pay out back to Dan so that he's going to be made whole from that. This becomes a problem sometimes when a person that wants to be conservator can't be bonded, and that may be because they've got criminal convictions for fraud or theft, or they've had a bankruptcy in their past, or some other reason. If they can't be bonded, then we have to consider who else might be able to serve as a conservator. This is a new requirement that has come down from the courts based upon some bad things that happened with some companies around the state of New Mexico, and it's an intent to protect the individual so that if someone does make off with their money, there's something there for them in the end. Next slide, please. Guardians and conservators have to keep separate accounts. This is going into some detail that we don't really need to for today's presentation. Next slide, please. There's reporting that has to be done. As I said at the beginning, that when you file a guardianship proceeding, then the individual and the guardian and conservator are under the jurisdiction of the court, which means that the guardian and conservator have to file reports annually with the court as to what is going on with the individual personally and financially, and those reports are reviewed. And if court doesn't like or doesn't understand what you put in your report, the court will set a hearing and bring the conservator or the guardian in to answer questions. So the courts are taking a really close look at what's going on in these cases. Next slide, please. So the powers of a guardian and conservator, as I said, the guardian basically has the power over everything physically, medically regarding the individual, and the conservator is all the finances. There's a lot of statutory requirements and things that the courts can order. We can always craft an order that is very specific to the individual's needs. There's some general things that go into every single guardianship and conservatorship order, but when there are specifics, we can certainly do that. For example, a number of cases I've had where the alleged incapacitated person is afraid of being moved out of their house when they don't want to or don't need to be. We can write into the order that before the guardian or conservator moves the individual from their home to an assisted living or nursing home, they have to get approval from the court to do that. That gives us just another level of oversight as an example. Next slide, please. There are visitation restrictions that have requirements for court approval. Now that we have these new rules, the guardian cannot restrict visits with the incapacitated person and other individuals without approval from the court. There's limits. You can restrict for 7 days, but then you have to go to court if it's a close family member or existing relationship. PP is a protected person, by the way. If it's someone who doesn't have a pre-existing social relationship, then it can be for no more than 60 days. So this prevents a guardian from basically saying, well, mom loves me best and she doesn't like my siblings, and so I'm not going to let mom have any communication with my siblings because I'm mad at them. They can't do that. The guardian has to allow visitations, and if they're going to restrict for any reason, they have to get approval from the court. So this is a new restriction on guardianship abilities. Next slide, please. Guardians and conservators, if they're professionals, have to be certified. This isn't as relevant to you all since you would potentially be family guardians, but just keep in mind if you're working with any professionals, if you need a professional to serve for your loved one for some reason, they do have to be certified as guardians and conservators both, and there's a whole process for that. Next slide, please. There is a grievance process if the individual, the protected person, or anybody else believes that the guardian and conservator is not doing what they're supposed to do. There's a grievance process that we can go through that can happen for the individual so that we can make sure that that gets reviewed. And at any time, any individual, whether it's the protected person, a guardian conservator, a family member, a friend, anybody who has concerns about what's happening in a guardianship and conservatorship case, can always bring that to the attention of the court simply by writing a letter to the judge. If you send a letter to the judge and say, hey, I think there's a problem here, this isn't right, the judge will set up the matter for a hearing and bring everybody in and to sort out what's happening. So there's always access to the court. Guardianship and conservatorship cases stay open until either the individual leaves the state of New Mexico or the individual dies. Unlike typical civil and criminal cases that end when the controversy is over, these cases remain open in the jurisdiction of the court until, again, death or moving out of the state of New Mexico. So the access to the court is always there for all the interested individuals with regard to these proceedings. Next slide, please. So that's it. That's a kind of the quick overview on guardianship. I can certainly go into a lot more detail about how they, what they do and how they work. But my point here really in bringing this to your attention is the juxtaposition between how much is involved in a guardianship proceeding and how expensive it is when you consider all the professionals that need to be involved versus thinking ahead and planning ahead and having powers of attorney in place that are much quicker and much easier to get done and cost a whole lot less than a guardianship proceeding. But certainly if powers of attorney aren't in place and the individual no longer has capacity, or if there's problems with the powers of attorney, then we have alternatives that we can help with. So that is all I have for today. and I'd be happy to answer any other questions, and I'm sure Dan would as well.
Okay, so we'll open it up. I believe there's not any questions in the chat right now, so if you feel comfortable or you don't feel comfortable unmuting yourself, you're welcome to type those in and we'll fill those questions. If you're not joining us through a computer and you don't have access to that chat capability, you're welcome to unmute your line and you can ask any questions. If you're on a cell phone, I believe you can push *4 to unmute yourself for this application, but let me just go ahead and see here. Oh, we do have a question. Does the New Mexico Bar Association have a guardianship program?
No, the Bar Association doesn't have a guardianship program. There are a couple of guardianship resources. There's the New Mexico Guardianship Association, which is a group of individuals and family members who have a connection to the guardianship world. That includes court visitors, attorneys who serve as petitioning attorneys or guardian ad litem, professional guardians, professional conservators, people who serve as fiduciaries, family members who are serving as guardians or conservators. So the New Mexico Guardianship Association is a wonderful resource. And we put on a symposium every year. There's educational opportunities and things through that. The Office of Guardianship is a state agency. It's not associated with the Bar Association. So it is an entity that serves low-income individuals who can't afford the process of a guardianship or afford a private guardian when there's no family member who is available to serve in that role. We have in New Mexico a number of wonderful guardianship contractors who work through the Office of Guardianship and basically Medicaid and are paid through the Medicaid program as opposed to being privately paid. When someone can afford a private guardian, it costs, there's a cost to that. We have, again, wonderful private guardians in New Mexico if there's not a family member or other friend who can serve. So those are options, but there isn't a Bar Association program. There are the Guardianship Association and then the Office of Guardianship through the Department of Health.
Okay, great, thank you. We have Dee Dee Shields who would like to unmute herself. So Dee Dee, you're free to go ahead and do that and ask your question if you'd like. If you go up to the top of your screen and you hover your mouse, a drop down will come down and it has a video camera and a microphone. You can click on the microphone and it will unmute you. I don't have the ability to unmute you. There we go. We hear you, Dee Dee.
You hear me? Okay, thank you. And thank you, Peggy and Dan. Just a real quick question during the time of Corona. I have been working with the state as a contractor for some of the court visitor and guardianship programs. The state bought 350 tablets for facilities so that instead of me going to interview people, they get a skilled or a person, a staff member to take that tablet in so that I can ask the questions. How is that operating in the private sector? I know that that's still how interviews are being conducted, but where is there a guarantee for those tablets? And is this the right venue to even ask this?
Yeah, that's a great question. And no, there isn't a guarantee for tablets. And so depending upon the situation, we're being really creative. I have interviewed people sitting outside the window. Well, if they happen to be on a first floor of a facility or can be on the first floor of a facility, we've sat outside a window and talked through the window with individuals.
Wow.
We have done Zoom. Yeah, we've done Zoom meetings, so video conference when that works, or FaceTime sometimes. We're just being as creative as we possibly can with the individual circumstances. And the courts are being very respectful and understanding of that as well. We've been having guardianship and conservatorship hearings by telephone, which is different. But on the upside, I actually had a case where I had a client who would not have been able to attend the hearing in person because he's his medical condition is such he could not leave the hospital. But because we were doing it by telephone, he was able to fully participate in the hearing by being connected by phone. So it's a different world, but we're being creative and we're making it work, because these things, we can't wait until whatever, August or October or December to take care of individuals who need help.
Right. I don't think we even have a date. So that is actually great news that somebody could participate that couldn't have before, so we can implement that in the future. Well, thank you. And thank you for this presentation and your time.
Of course.
So some individuals lost connection. Just so you know, the presentation is being recorded, and it will be posted at our alz.org/New Mexico website, or you can always email me again at dnparras@alz.org, and I can send you a link to the presentation if you lost connection during today's discussion. It was some great information. I really am thankful to Peggy Graham and Daniel Monte from their law office providing this information to us.
And I'll just say real quick, and I'm sure Dan, I'll speak for you as well, and you can shoot me later. If any of you guys have particular questions about what we've talked about, I'd be happy if you can shoot me an email, and I'd be happy to further discuss with you about whatever your situation may be.
Sure.
Yeah, I would as well.
Great. If you guys want to just send us your or mention your emails, I'll type it in the chat, and hopefully they can get connected to you if they need to.
Well, I think I can type my email into the chat, my phone.
Okay. If you would do that, that would be great, so we don't miss any characters in that email. Would be great if you would share those. Their contact information as far as phone is 505-872-0505. They are also at www.pbwslaw.com. Again, if you have any of our association needs with the Alzheimer's Association, you can always call our 24/7 helpline, 1-800-272-3900, or you can reach me at my email at dnparras@alz.org. We have posted some information in the chat. Peggy is mgraham, GRAHAM, at pwsla.com. We have Daniel at DMONTE at pbwslaw.com. If there's any other questions, we can leave it open for just a few more, maybe 30 seconds, and then we'll go ahead and let you guys go. We are super thankful, Peggy and Daniel, again, for this information. This is one of our requests within our association a lot of times, so we really value your information that you were able to provide us today.
Absolutely.
Definitely. Our pleasure.
Thank you. I'm going to stop the recording. And again, if you guys have any questions or need the presentation link, we'll go ahead and provide that to you.